Okay, we're going to go ahead and get started. Thank you everyone for attending today's webinar, Managing the Risk of ADA Compliance. Our partner today is PUA, and our speaker today is Kent Holland. Holland Company is a registered provider with the American Institute of Architects continuing education system. Credits earned based on the completion of this program will be reported to AIA CES for AIA members. Please send your AIA member number to lledbetter@hollandcompany.com after this presentation for the reporting. Today's course is registered with AIA CES for continued professional education. As such, it does not include content that may be deemed or construed to be an approval or endorsement by the AIA of any material of construction or any method of manner of handling, using, distributing, or dealing with any material or product. Questions related to specific material, methods, and services can be addressed at the conclusion of this presentation. PUA is an important partner with Holland Company and is a leading carrier in providing insurance for the A&E industry. We appreciate their partnership and their dedication to our insureds. I'm going to go ahead now and turn it over to Kyle Burns, who is with PUA.
Welcome, everyone. I'd like to thank Laura and Jessica and the team at Holland Company for organizing the webinar and inviting us to participate. PUA is the exclusive managing general underwriter for Arch Insurance Company's design and contractors professional liability. I'm happy to introduce Kent Holland as our presenter today. We're asked all the time what differentiates our product in the marketplace, and the easy answer is Kent. Kent's the best in the business and provides a full suite of risk management services to our Arch clients, which includes webinars, unlimited contract reviews, and he mans our 1-800 hotline for loss control. With that, I'll turn the floor over to Kent.
Thank you, Kyle. So today we'll be talking about ADA compliance and how to manage the risks of ADA compliance. What we have in our slides today is probably a good wealth of information that I hope that you can use these slides as a permanent resource. I like to put enough content in the slides that they're worth saving. You can go back and reference them. I do have a few examples of court decisions that have addressed ADA compliance, and in particular the ability of a design firm to seek to be indemnified by its client for damages, or the other way around, whether your client wants you to indemnify them for their damages arising out of ADA compliance, and how courts have been handling that differently around the country. And I conclude with some suggestions for contract language that you can add to your design professional contracts to address compliance with ADA, compliance with law, codes, regulations, and establishing the standard of care for that type of compliance rather than warranties. So that's sort of the direction that we'll go in today. So just starting with the first slide, you should be looking at slide number 5 on your monitors. And just the facts, what are the facts concerning ADA? This document that I'm going to be referring to was published on July 12, 2018 by the uscourts.gov website. It's a great site to go and get really detailed information concerning ADA. The points I make here are that while the overall civil rights cases have been declining in number, and ADA is a civil rights issue. It's not a code. It is actually part of the civil rights regulations. And civil rights cases have been declining, but cases brought under the ADA have been increasing. And in fact, they have increased threefold over recent years. And filings in 3 states, those being California, Florida, and New York, account for over 50% of the ADA cases filed in the U.S. In the 12-month period ending December 31, 2017, the number of civil rights cases filed in district courts was 39,800. That amounted to 14.5% of the total civil docket. ADA cases accounted for over 10,000 of those filings, and that amounts to 4% of the total civil docket. and 27% of the civil rights cases. So it gives you an idea of how significant ADA litigation is. From 2005 to 2017, the filing of civil rights cases, excluding ADA cases, actually decreased 12%. But in contrast, during that same period of time, filings of ADA cases increased almost 400%. Now, a lot of those cases have nothing to do with what we as design professionals are dealing with. A lot of those are dealing with websites being ADA compliant and all types of things being ADA compliant that are not something you might be designing as far as a building. So when we look at these numbers, these are not all by any means addressing buildings or construction sites. Many of these deal with have you made websites able to be accessed by people with disabilities. Okay, so the code is 42 U.S. Code Section 12101. And again, the ADA is not a building code. It's a federal civil rights law, and it prohibits discrimination based on disability. It's enforced by the Department of Justice, the United States Department of Justice. And individuals can file complaints with the Attorney General, who is authorized to bring lawsuits in cases of general public importance. So this is kind of unique among the various things that we have to comply with, in that the United States Department of Justice ends up driving a lot of this litigation. It applies to both public and private commercial buildings. Of real importance to us, there's no grandfathering of buildings with respect to ADA compliance, and the ADA requirements can be subject to, vastly different interpretations, especially when we're dealing with an existing building that's being renovated. What is required when you're renovating a building? Accessibility requirements can often be a source of conflicts with the code requirements. So you may have a building code that is requiring you to do some very specific things concerning state code or local codes, and yet to do those things may run afoul of ADA requirements. So there can be conflicts. Many states and local jurisdictions have their own accessibility laws. So in addition to the ADA laws that the Justice Department is enforcing, you need to be familiar with the accessibility laws in your own state or local area. The building code inspectors can determine compliance with local and state laws, but they are not to be ruling on compliance with ADA, at least not federal ADA under the civil rights laws. I think building code inspectors may be able to look at ADA issues arising out of your local ordinances that may have created ADA compliance issues as part of your local ordinance or code. I'm at slide number 9. ADA standards establish design requirements for construction and alterations of facilities subject to law. It applies to places of public accommodation, it applies to commercial facilities, and it applies to state and local government facilities. So really, the universe of where the ADA applies is very broad. Now you're going to see that there's some places where ADA does not apply that actually might surprise you. But there's what's called the Access Board, and it is responsible for developing and updating design guidelines known as the ADA Accessibility Guidelines, ADAG. And they're used by the Department of Justice and the Department of Transportation, both on the federal side, in setting and enforcing standards that the public has to follow. So both DOJ and DOT's current ADA standards are based on the Accessibility Board's updated ADAG from 2004. As a result, for the most part, the standards of DOJ and DOT are similar, very similar. But they contain additional requirements that are specific to the facilities of their respective agencies. The DOJ ADA standards apply to all facilities except for public transportation facilities that are subject to DOT standards. This becomes important if you're, for example, doing highway design work or anything that is subject to DOT. Then you're not going to be looking at DOJ's standard. You're going to be looking at DOT's standard. So those of you who are designing where you have federal funding or federal DOT standards being imposed, you're going to be looking to DOT standards. Now, for the purposes of our webinar today, I couldn't go into the minutia, the great detail on what applies, and it is really voluminous. But a lot of it is available right on these websites that you can go to. It's just a wealth of information in these regulations, these manuals, these standards, where you can go through and see what's required for bathrooms, what's required for DOT, what, really detailed requirements. We're today doing more of a broad brush review. So the United States Department of Justice develops and enforces regs that implement the ADA. And as noted on slide number 11 here, after the ADA became law in 1990, the DOJ created the first set of Title III regulations. They were the 1991 standards for accessible design. The most recent version of the ADA Title III regs is the 2010 standards for accessible design. And the section of the DOJ Title III regs that specifically apply to existing facilities that you might be renovating, those are at 28 Code of Federal Regulations, section 36.304. And most of these requirements for existing facilities were actually part of the 1991 standards, haven't changed that much. Section 26.304 reiterates the statutory requirement that architectural barriers be removed in existing facilities when readily achievable. But the section also provides 21 different examples of steps that can be taken to remove barriers. And I'm going to go through some highlights of some of these examples. But before I go there, just note that the architectural barriers have to be removed only when it's readily achievable to do so. You don't have to structurally change an existing building in order to achieve ADA compliance. But probably if there was a column that is preventing ADA accessibility, and that column is a small column that could easily be moved out of the way during a renovation, and portions of that building could be supported with LVLs or new beam work connecting other larger columns that you could put in, then one could argue that maybe that is readily achievable and you need to do that. One of the problems that I find with ADA is that I like to call it the government green eye shade type person who is evaluating whether we complied or not. And so even though 9 out of 10 engineers would have looked at something and said, no, that's not readily achievable, or we don't need, that's not necessary for ADA. At the end of the day, that decision is actually made by somebody from the Justice Department deciding whether you complied or not. And that's really befuddling, because we want to be able to argue that we did what was reasonable, what was necessary, what was prudent. We met the standard of care. And you'll see when we get into subsequent slides, I'm going to focus a lot on making your services subject to the standard of care and not creating an absolute warranty of ADA compliance, because we want to be able to defend ourselves by saying, with an expert witness that says, we designed it appropriately, even though the government may ultimately decide otherwise. We designed it appropriately. We need that defense. So what are the ADA standards for accessibility? On slide 13, the ADA regs and ADA standards published in 91 set the minimum standard for what makes a facility accessible. They were updated 2010 standards, retain many of the original provisions of the 91 standards, but they contain some differences. These standards are key for determining if a business or a facility is deemed accessible under the ADA, but they're used differently depending on whether a facility or a business is altering an existing building, or if it's a brand new building, or if it's removing architectural barriers that have existed for years. So there are different ways of applying the ADA standards to different types of buildings. Of real importance, there's no grandfather clause. I'm at slide 14. And I don't know whether the slides, when I go to a slide, whether I probably need to pause and let it catch up before you see it on your screen. So I'll pause a moment before I move my slides going forward. The ADA does not contain a grandfather clause for older buildings. So instead, existing facilities of public accommodation, those that are built before 1993, must retrofit their facilities and remove readily achievable barriers. So in other words, just because the building was already there before the new ADA law became effective, doesn't mean that you don't have to comply with ADA when you go out and renovate an existing building. Now, it doesn't mean that you have to go out and correct problems in all these buildings immediately, but if you're renovating, you certainly have to retrofit to remove those readily achievable barriers. And so there's really a push right now for buildings that pre-existed the law for their owners to retain architects and engineers to go in, look at those buildings, figure out what can be readily changed to facilitate ADA compliance. Facilities that were constructed for first occupancy after 1993, they've got to be accessible to people with disabilities to the extent that it's not structurally impracticable to do so. There are revised regulations for new construction or alterations beginning after March 15, 2012. Those are the new 2010 DOJ regulations. I'm moving to slide 15. And before I do that, I see somebody asked in the chat room about Fair Housing Act requirements tied to the ADAG. Yeah, there are Fair Housing Act requirements. This is a different set of requirements, Fair Housing Act. And what you'll find is in a lot of the litigation that we see against project owners and sometimes designers is you've got the Fair Housing Act, and they'll make allegations under the Fair Housing Act. And then the same complaint will also have ADA allegations. So you'll find lawsuits that contain counts against generally the project owner based on a failure to meet the requirements of the Fair Housing Act as well as the Americans with Disabilities Act. If you fail to comply with aspects of the ADA, that could cause a violation of the Fair Housing Act at the same time. So a lot of these things go hand in glove. Okay, now let's look at litigation. The ADA does not have a pre-suit notice requirement. So unlike some of the litigation in California concerning construction, where you don't just go out and sue somebody, first you give notice, you give an opportunity to correct a defect. There are a lot of things that people go through. ADA litigation is different. Litigants can merely drive by a facility, recognize an alleged violation, and immediately file a lawsuit the same day. So while there are no damages available to claimants under Title III of the ADA, businesses could be subject to the expense and embarrassment of having to modify non-compliant buildings and or websites. So injunctive relief, court costs, attorney's fees, they're all appropriate remedies that provide ample reason for plaintiffs' attorneys to fire off these what we call drive-by lawsuits one after another. And I mean, there have been hundreds, if not thousands, of these drive-by lawsuits. There has been evidence that one or two firms, maybe more, have one or two plaintiffs, maybe more, who are in wheelchairs, and they literally run around the country and they just get off the plane, they get in their wheelchair, and they just start driving by and saying, yep, that's not compliant, that's not compliant. There were a number of lawsuits against Archstone apartments around the country where these drive-by suits alleged any number of violations, and you get into the details of some of those violations where it's actually more than driving by on the outside. They have somebody with a wheelchair goes inside and tries to get into the doors of the units, goes in, finds bathroom doors are too narrow. There are not a sufficient number of accessible units with showers that you can roll directly into. There are not enough units where the cabinetry is low enough for a wheelchair to go up and use a sink or reach the cabinets. And what ends up happening is these suits will allege 1,000 violations in an apartment complex. And each one of those violations has ramifications and costs associated with it. So most drive-by suits, I'm at slide number 16. Most drive-by suits involve individuals, attorneys, or their, quote, expert witness driving by a place of business to determine whether there exist any architectural barriers or for the disabled individuals. Commonly, the removal of barriers includes installing ramps, having accessible parking spaces, widening doors, installing grab bars in lavatories. However, more extreme modifications may be necessary where readily available. Again, one of the Archstone cases is very instructive as to the types of things these suits allege. And I wrote an article about one of those cases involving Archstone on my website. I maintain a lot of articles, case notes on litigation at www.constructionrisk.com. It's all free. You can go there and just type in ADA or Archstone, and these cases should pop right up in the search bar, and you can go right in and find old newsletter articles about these cases. So if you want to dive more into the weeds and the details, you can go there and look at those. So commonly, the removal of barriers includes installing ramps, putting in accessible parking spaces, widening the doorways, installing grab bars, etc. But courts are going to look at factors like the nature and cost of removing the barrier, the overall financial resources of the facility, the financial resources of the covered entity, and the type of operations the covered entity engages in. You know, what are they really doing to justify having to do these changes? Do they have a lot of people from the public coming in? Who's using the facility? What kind of services are being provided? These are considerations in deciding whether they were readily achievable and really kind of economically made sense. Again, it's a subjective call. There's not a real line in the sand on a lot of these issues. On other issues, it is pretty clear cut, you know, as far as widening doorways. I got to tell you, I've been in some older facilities that are adult care centers, or not so much adult care centers, but they are independent living centers for adults to have their own apartments. My mother lived in one of those. And you go into the bathroom, you couldn't get a wheelchair in the bathroom, and the doors go the wrong direction, and the cabinets are too high. And, you know, I look at it and I'm like, you know, this should be changed, you know, maybe not while the individual's living in the unit, but when they move out, maybe it should be changed before the next person moves in. Is that readily achievable? Well, there's nobody in that unit. How much is it going to cost to simply take a Sawzall and widen the door in the bathroom and fix the electrical so it doesn't get cut when you use your Sawzall? I mean, there are some sort of no-brainers that even the DOJ could get right when they're evaluating this. Now let's look at new construction requirements. So I was just talking about existing and fixing things in older facilities when you know that people are going to be using those facilities for certain purposes. So all new construction and modifications to public accommodations and commercial facilities have to be built in compliance with the ADA requirements. Title III specifically states that for public accommodations, discrimination includes, quote, failure to remove architectural barriers in existing facilities unless it can be shown that it's not readily achievable. We've already talked about that. not clear from the statutory language who has the burden of proving that, I'm at slide 18, by the way, not clear from the statutory language who has the burden of proving that removal of an architectural barrier is or is not readily achievable. Who has to prove that, the government or the facility being sued? Is there a presumption that is in favor of the building owner or a presumption in favor of the government in this case? Issues like that haven't been ultimately resolved. Right now, what tends to happen is these suits are coming in and the building owners are having to comply, and they quickly try to bring their buildings up to ADA compliance without having a court order it. While the plaintiff would need to assert that the barrier removal is readily achievable, some courts have viewed readily achievable as a good defense, saying, well, wait a minute, it's too difficult to do that. So the defendant facility would need to ultimately prove that barrier removal can't be readily achievable at a reasonable price or with reasonable work. Now, there's a DOJ safe harbor, and I'm at slide number 20. And I'm probably about halfway through the presentation, and I want to leave some time for questions at the end. And I see there was a question here asking about slides being provided. Yes, all these slides are going to be provided, content in these slides. Like I said, I like to put a lot of words on my slides. Some people say speakers should only use bullet points and just a few words. I don't believe in that for what I'm presenting. I like you to be able to save this on your computer or print it in a notebook. And
Kent is working on getting the sound back. Sorry, guys. I'll go ahead and take this time to remind everyone at the end of the presentation, we'll also do another reminder, but we will be sending a link tomorrow so that you can get your.
Okay, this is Kent Holland. Can please confirm that you can hear me?
We can hear you, Kent.
Okay, great. I'm sorry, my call got dropped, so we're back. Okay. All right. I was just saying that you're looking at slide 20. As with most of my slides, I have way more content than probably I should put on a slide, but I like to have enough content that you have this as a permanent resource to look at in the future. So on slide 20, we're saying ADA Title 3 regs have a safe harbor, and it states that a facility elements built or altered after March 15, 2012, and that comply with the 91 standards don't have to be changed to satisfy the new 2010 standards. So if, however, an element already existed but did not comply with the 91 standards prior to March 15, 2012, then that element has to be modified to meet these new 2010 standards to the extent readily achievable. So you can see in that little litany of dates there that this can get pretty confusing, and you need to be familiar with the different standards and what the safe harbor is and what you do to comply during those various periods. The safe harbor provision does not apply to elements in the existing facilities that were not included in the 91 standards, but now are regulated in the 2010 standards. So those elements have to meet the 2010 standards to the extent readily achievable. That's a mouthful. So a good reason for you just to look at that slide and go back and actually read the standard that's on the DOJ website to understand it better. The following are examples of elements that don't fall into the safe harbor provision: residential facilities and dwellings, amusement rides, recreational boat facilities, golf courses, play areas, and swimming pools. The DOJ website has a checklist for readily achievable barrier removal that was last revised in 1995, and the checklist is intended to be used when surveying an existing facility. The Institute for Human-Centered Design has an updated ADA checklist for existing facilities. It incorporates those 2010 ADA standards, and it includes the more recently added elements that don't fall under the safe harbor provision that we were just talking about. So the ADA checklist by the Institute for Human-Centered Design is a good resource because it tries to pull together the pieces of these different laws and requirements into one place so it's more easily digested and understood. Now, there are certain exemptions that we should be familiar with. What about churches, synagogues, mosques, and religious entities? Are they exempt? Well, there is a specific exemption for religious entities in the ADA. And there's a lot of misunderstanding about this exemption. It covers all the programs and the activities of the religious entity, even if it is not an actual religious program or activity. Meaning it doesn't have to be a worship service that in order to be ADA exempt. It could be, the soup kitchen or something else in the facility, a meeting room that's made available to the public. If it's inside of a religious building, then it's exempt. Now, having said that, you can look at a lot of churches and older buildings that clearly were built, in the 1920s. They're old historic buildings, and the steps going into those buildings are astoundingly steep. It's hard for an able-bodied person to walk up some of those steps. And under the ADA, you may not have to change those steps. And under the historic preservation laws, you may not be allowed to change those steps. But a lot of local ordinances are requiring that these facilities, to the greatest extent possible, go ahead and find a way to put a ramp somewhere. So you will see you are going to have local requirements to devise ways to put ramps to get into those buildings. So again, just because ADA doesn't directly apply, it doesn't really give you a free pass from what local jurisdictions are doing. Courts have interpreted the private club exemption. Now, this is an interesting exemption. So private clubs don't have to comply. So courts consider, do members have a high degree of control over the club operations? Is the selection of members highly selective? Are there substantial membership fees? The entity is operated on a nonprofit basis. The club was not founded specifically to avoid being covered by federal civil rights laws. So these are some of the considerations that courts look to. The private club can lose this exemption to the extent that the facility is made available for non-public members to use. So I go to golf courses where I may be a speaker at a program, and they bring in all kinds of people. You might have your local AIA chapter, or maybe the insurance broker invites everybody to the local golf club for use of their community room or one of their dining halls for these engagements. That would probably cause the golf club to lose its ADA exemption because it's being used by the public to come in. If they want to really maintain their ADA exemption, then they would need to carefully control who gets to use the club. So I belong to a club that there's just absolutely no way to get into our locker room if you're in a wheelchair, because you come in the front door of our club. The first thing you have to do is go up several steps to get into the main lobby, and then you've got to go down 8 steps to get down to the locker room, and there's no elevator. Well, there's no requirement that they put an elevator in there because it is a private club. We pay dues, and we control the club. What's considered an alteration under the ADA? I'm at slide 25. When any business makes an alteration to a facility, it has an obligation to make that accessible to the extent possible. And alteration is defined as remodeling, renovating, rehabilitating, reconstructing, changing, rearranging. You can see the universe of what's considered an alteration under the ADA is broad. Examples of alterations include restriping parking lots, moving walls, moving a fixed ATM to a different location, installing a new sales counter or display shelves that are more accessible. Again, changing doorway entrances and replacing fixtures, flooring, and carpeting. Normal maintenance like re-roofing, painting, wallpapering, not considered an alteration. But again, if you do any of these alterations, then you need to be looking at ADA to see if ADA requires you to do things particular to meet the ADA when you're doing these. Okay, going to contracts now. ADA standard form agreements, our industry standard form agreements, talk about some of the code requirements. Well, B101, which is a form that we use a lot as architects, it references legal requirements, but doesn't explicitly require code compliance. So the way they say it here, you can see in 3.15, 3.21, and 3.4.2, talks about the architect having a duty to incorporate into the contract documents design requirements of government authorities. Okay, so that could be codes, laws, rules. It could even be ADA. So that would be the way you pick it up, is sort of that indirect language rather than saying thou shalt comply with code. They pick up some of these issues in this more indirect manner. There's no reference to legal requirements in the C401, but under section 1.3, the requirements of the architect's prime contract with the owner flows right down into C401 for the subconsultant. So again, you end up picking up whatever requirements the architect had with regard to ADA and code compliance. And the standard of care for the C401 is identical to the B101. EJCDC, the Engineering Joint Contract Documents Committee, this would be the owner-engineer professional services agreement used for large infrastructure, generally horizontal type design. You can see the standard of performance. The engineer shall comply with applicable laws and regulations is what it says. And then they have a definition of laws and regs. It says all applicable laws, rules, regs, ordinances, codes, and orders of any and all governmental bodies. Design Build Institute of America, slide 31. I have the definitions and the legal requirements from that document. So if you are doing design build work, be familiar with these. Again, it says the consultant agrees to perform the services in accordance with all applicable legal requirements. By the way, I prefer the language of DBIA over EJCDC. We say we agree, but elsewhere we've already said anything we agree to, we're only agreeing to do it per the standard of care. Whereas the way EJCDC says it, says we shall perform consistent with the standard of care. I'll go back to it. Shall comply with applicable laws and regs. I actually always change that when I review contracts, and I say we shall exercise the standard of care to comply with the applicable laws and regs rather than an absolute commitment. The reason I do that is some courts have said that if you say in your contract you will exercise the standard of care, and then you say, and we shall comply with applicable laws and regs, then what that means is two different things. You're exercising standard of care, but you've warranted compliance with laws and regs. That, of course, is an uninsurable warranty to be avoided. So common contract law language requiring code compliance. I've got an example here on this slide 32. Consultant agrees its design will comply with all laws, regs. I say consultant agrees to applicable exercise, it should say to apply the standard of care, to the applicable exercise of standard of care. I kind of messed that wording up. I apologize. Alternative wording, and we go to slide 33. We've got standard of care language out of B101. You can see here on Article 2.2, good wording for the language. We also have more specialized standard of care language that might show up saying we'll comply with the standard of care of other professionals with experience in designing art museums in major cities. I find that generally okay. We're saying that you're not going to judge us by the standard of care of designing a house when what we're really designing is an art museum. So you could agree to that and still, I believe, be okay within the insurable standard of care. The key is, I'm at slide 34, you don't want to warrant that the design is going to achieve a certain rating or qualification, or that the standard of care for a specialized project should generally, as long as you don't warrant that you're going to meet a rating or qualification, then you should be insurable. You want to avoid using words like you're going to meet the highest or the best quality. The way I look at it is you can warrant that you have your licenses, that you have enough people, that you have enough finances to do the services. What you don't want to do is warrant that you the quality of the professional services. So that's the part of your contract that I pay attention to. I want to delete any reference to the quality of your services. So we're not going to warrant that we're going to meet the highest or the best quality. Now, some clients will not agree to expressly tie ADA compliance with the standard of care. So like I said, if the contract says we shall design the building to meet all codes, regulations, and ADA requirements, I'm going to say, no, we shall exercise the standard of care to do those things. Some clients push back and say, no, I don't want to put the standard of care. But some of those clients who won't do that will at least acknowledge that compliance with the ADA is subject to reasonable interpretation. So I've added the following in my example wording where I say, okay, we agree we'll design to comply with the laws. And I say, this does not, however, constitute an absolute warranty or guarantee concerning professional services. Common contract language requiring code compliance. So here's an example. Consultant warrants that its design will comply with the laws, regulations, etc. That's terrible. And I actually see that in some contracts. Again, we want to delete the word warrants and say agrees. And then we say in accordance with the standard of care. So we agree that we're going to comply with it and we're going to do it in accordance with the standard of care. I'm at slide 37. Agreement to indemnify the project owner for penalties due to violations of the ADA. Now, this is an interesting case. This one comes out of the federal court responsible for Nevada. And in this case, the design professional agreed by contract to indemnify its client, the project owner, for any damages arising from any act, omission, or willful misconduct. Now, I can't let that language go without commenting on it. If I were reviewing your contract, I would have redlined that and said, not any damages arising from any act. I would have said any damages to the extent caused by, because the word arising is extremely broad, and courts look at that language and say, oh, that means you thought about the project and we're doing some design work in your head while taking a shower. That's good enough to cause you to have to indemnify. So we don't use the word rising out of. We want to say to the extent caused by. And then we sure don't like any act omission, because we could have an act or omission. It could even be an error, but it's just a non-negligent error. There are mistakes made on every design. There's not a such thing as perfect design. That's not what the client's paying for, and the courts do not require perfection. So I would have said arising from any negligent act, error, or omission, or willful misconduct. So anyway, having said that, even if you'd done all that, the court says that provision cannot be enforced when the damages arise out of an ADA. So this project owner was not able to recover from Rolf Jensen for the ADA damages that the project owner had to pay. The court said that permitting that kind of indemnity would weaken the owner's incentive to prevent violations of the ADA, and therefore conflicts with the ADA's purpose and intended effects. So and I have a typo in this slide. Sorry, I'm seeing more typos than I would like to see in my slides, and I will fix those before we give them to you. The point of that litigation, and that same result has occurred in 2 other cases around the country. The court is saying that the ADA is really designed to make project owners behave in a certain way and design to be ADA compliant, and that the project owner should not be able to shift that responsibility to the designer. Now, I got to tell you, to me, that never made any sense because the project owner typically doesn't know anything about how to design a building. They have to rely on the designer. And I don't see anything that would be inconsistent with the federal law, why the federal law should be interpreted as preempting the ability of an owner to get that kind of indemnity. So if you're looking at the slide number 38 that I just put up, which is LA and AECOM, this case actually said exactly what I'm saying. Here, disabled individual sued LA for alleged failure of the city bus facility to meet accessibility requirements. The city filed a third-party claim against this engineer and its contractor for indemnification for the damages. And the city contract with the engineer required the engineer to defend, indemnify, and hold harmless the city against all suits to the extent that any such claim results from negligent and or intentional wrongful acts. Let me stop right there. Notice the wording in this one. To the extent, excellent, they got that right. To the extent caused by, they did it right. Notice it says from negligent act or intentional wrongful act or omission. They got that part right, so that's good for them. What did they get wrong in this? How about the duty to defend? That's an uninsurable duty. They should never have agreed to defend the city because now if the insurance company for AECOM has said, hey, I've got to defend the city, the insurance company is going to say, yeah, well, look at your insurance policy. It says we don't have contractual liability to cover your defense obligation to the city, so you're going to have to pay those city defense costs yourself, Mr. Engineer. So we would have wanted to get rid of that wording. Nevertheless, the court here says that the city prevails against the engineer, and indeed, AECOM would be required to indemnify and defend the city against this claim, and that defense, of course, will be at the AE's own cost. I believe that we're going to see, if this ever gets to the Supreme Court, since we have different decisions from different circuits around the country now, I would assume that, I would hope, I guess, I don't know, I should say hope, but I really believe that the Supreme Court would decide along the lines of this LA case that it's okay to have the AE agree to indemnify the owner for ADA damages. Okay. I have slide 39 on the screen. If ADA compliance is anticipated to be an issue in the project, consider adding a provision like the following, and I'm not going to read this, but basically I'm saying, look, it's a subjective thing. You know, the owner acknowledges and agrees that it's not a detailed building code, etc. So at least it sets forth the expectations of the parties. And I wanted to have other language in here, so I'm just going to talk through the last part of some of my contract clause language that I like to put in. And before I do that, I do want to put my disclaimer. So I always use this disclaimer because we're going to talk about contract wording. And what I would say is, I'm talking generically. I don't know where you're located. I don't know if you're in California or Florida. I don't know where you might be around the country. What is permissible in your contracts varies from state to state, and you should be talking to attorneys familiar with construction law in your state for actual advice. But having said that, when I review contracts, and I do it all around the country, there are certain generic things that I like to do. And I've hit on a bunch of those points as I've been talking about contract wording. But I do like to have a limitation of liability clause in the contract that will deal with things like ADA damages. And so we add in every contract that we review, we would like to see you as a design firm in your standard terms and conditions, including a limitation of liability clause, so that when you give your proposal to your client that has your pricing in it, your scope of work, and your standard terms and conditions, we would like to see it include a limitation of liability clause that says that your liability will be limited to a fixed dollar amount or your fee, whichever is more, and that is going to apply to all damages arising out of any cause of action, and then we have to define to say including breach of contract, warranty, strict liability, negligence, errors and omissions. We list them all out because some courts will say that the limitation of liability clause only applies to the type of action you specifically mention. We also like to include in that wording a statement that the limitation of liability applies not only to the corporation, the actual AE firm, but also to claims against any individual employees or principals or officers of the firm. That's important because there are states like Florida where an action came in against an engineering firm and an individual engineer. So the plaintiff sued the individual engineer that drew up the plans and specs and his firm. And the court said, yeah, you've got a $50,000 limitation of liability. That's going to apply to the firm, but it doesn't apply to the individual because it didn't say it did. Well, that's terrible. So now the plaintiff was able to recover $1 million from the individual engineer, but not the engineering firm. Now, of course, at the final analysis, the individual engineer is covered under the engineering firm's policy. So what that really means is that that $1 million claim by the plaintiff is simply picked up by the insurance company for the engineering firm. It's not paid by the individual engineer. But because that clause did not include the limit and make it apply to the individual, the engineering firm and its insurance carrier ended up ultimately responsible for the $1 million. That has since been fixed in Florida. And now, if you are in Florida, there is very specific language that you add to your contract. And I'm going to mention this because in addition to that LOL clause that I like to put in the contract, I like to add a clause saying that there's no individual liability of any individual, no personal individual liability. And we can make that mutual. It can be for the owner and for us. But if you're in Florida, you have to refer to the specific statute, and you have to use all capital words, and it has to be 5 font sizes bigger than the rest of the contract to make that statement stick. So again, be familiar with what your state law requires in the way of disclaiming personal liability. Another clause that I really recommend that you include in your contract to avoid some of the ramifications of dealing with ADA damages is a waiver of consequential damages. So in this case, in all the cases that we've referred to, the damages that we're talking about for ADA damages are not because somebody slipped and fell and had bodily injury or actual property damage. The damages are the cost of the owner having to go and retrofit a building to make it ADA compliant. And in the case of Archstone, it cost, the claim was over $1 million. And then they make that claim against the engineer or architect to recover those costs they had to pay. Well, those are economic consequential damages. So if we had included in that contract a mutual waiver of consequential damages, similar to the clause that's in the AIA B101 contract, it says that both parties agree to waive all consequential and indirect costs. And that's about all the AIA says. I like to add to that, and in the form I use, I say including lost profits, lost rents, all those types of things as examples of what we mean so that a court understands what is consequential, because the word consequential isn't really very well defined. Courts come up with different meanings for it. The clauses that I am mentioning, you can find these clauses on my website. And so I'm not going to put them into my slides I'm sending you. Just go to my website, again, ConstructionRisk.com, go up to the top menu bar, and you'll see in the menu, it says design and construction contract, something like that. And then there's a drop down, it says template of reasonable design clauses. And in that, I've got these clauses, a reasonable mutual waiver, limitation of liability. These are all good clauses. You can just copy and paste them right out of my website for free. Okay. Back to limitation of liability, just one last point on that. If you include that in your standard terms and conditions, and then your client, your owner, strikes it, I like to be able to go back and argue with that client owner and say, wait a minute, you're trying to take my proposal with my pricing and delete a fundamental assumption by which I priced my proposal. And if you're going to remove my LOL and make me do it with no limitation of liability, you need to pay me for that. And I have some engineering clients that say you have to pay 1% of every additional $100,000 in construction costs. So if you're going to go from my limitation of liability, which I offered of like 100,000, and you're going to say, oh no, we want $2 million. Well, you got to pay me $19,000 for that. And sometimes the owner will, argue, like, well, I'm not paying any extra. And they're like, well, let's agree to not have an LOL, or at least you can negotiate it down to something reasonable. Okay, let me see if you've got any questions here that I need to answer. Yeah, good point. Standard municipal contracts, they're not going to agree to limitation of liability. Federal contracts, you're not going to get a limitation of liability. So for the most part, when I'm talking about these good LOL clauses, waiver of consequentials, I'm talking about commercial contracts. We all understand that when we're dealing with municipal owners, we don't get the same. I would say this, however, a lot of you are going to be sub-consultants to prime architects. And just because that prime architect did not get an LOL clause in its prime contract with whoever its client is, doesn't mean that you shouldn't be asking for it in your contract as a sub-consultant. And often these primes will come back to me and say, we couldn't get it in ours, we're not giving it to you. And I'm like, yeah, we're only doing a $10,000 fee project. We're not going to give up our entire company and our entire insurance program for the privilege of doing a $10,000 fee. You've got to give us an LOL, and we negotiate and we get something. Or at least we get a waiver of consequential damages. What we'll sometimes do is it might say that waiver of consequential damages won't apply to damages that the prime has to pay under its own indemnity clause for bodily injury property damage. We can exclude that out. Let me see if there are any other chat room questions. Anybody have any other questions for me? Let me see.
Okay, there is some in the question and answer section. There's
oh, Q&A. Okay, let me look at Q&A. Okay.
You want me to go ahead and read them for you?
No, I'm reading it.
Okay.
Okay, I'm going to go to the very last one I see here first. We're designing shoreline protection along a public street and walkway for a municipal public works department. The client declined our offer to provide shoreline access in our design, and our scope of work states explicitly that beach access designs are not required. Is ADA access to the shoreline required? Do we have a professional obligation to highlight ADA access as a potential liability to our municipal client? Okay, I do not know enough about whether or not the ADA specifically applies to that, but I don't see why it wouldn't apply to that. And I think you are wise to advise your client that they need to consider this. And this gets to the issue of a lot of times we will tell our clients that they ought to do something and they decline to do it. They don't want the expense. At a minimum, I would put in my contract that you have advised the client that this may be subject to ADA compliance. You don't know for sure, but that in the event that there is an ADA complaint against your client arising out of that design, that they specifically agree to indemnify you, hold you harmless from any damages arising out of that decision. So you want to really put that in their face and have them sign off on that. And I have done that to clients, and it really makes them sit back and go, whoa, wait a minute, I don't want to do that. And then your answer is, well, then pay me to design it correctly. All right, let me look at another one here. Oh, I think I've just dealt with this one. Is there any way to contractually limit ADA compliance on a project if the owner doesn't want to pay for it and the reviewing body is not choosing to require it when you know it should be required? Same answer. I'd say if you really feel it's required, then you ought to be addressing that in writing to your client and telling them that this is how you would do it. And if they choose not to, it's sort of like where a client chooses to select a product or take a vendor's piece of equipment that you don't want. You don't want to pick up liability for that. You need to have an indemnity and hold harmless saying you're not responsible. They should sign that for you to protect you. Because the problem is, even though your client and the current ADA reviewers don't think it's necessary, the statute of limitations doesn't pass on this thing. 3 years from now, you can have a drive-by person come by and file a claim that goes to the Department of Justice to make a determination, and they come in and they nail everybody. And the fact that your local client and your local ADA compliance people waive the requirement doesn't really protect you against this overall claim. Oh, question about historical buildings. Is there an ADA blanket exemption? I'm sorry, I don't know the answer to that one. Okay. There are impractical changes and there are varying interpretations or errors in ADA interpretation. That's for sure. How significant are the ADA penalties? So they add up. And so each individual penalty, like I mentioned with the archstone, it's significant. Plus the plaintiff gets their attorney's fees. So the attorneys, the incentive for the attorneys, they're making a fortune off of this. They go and hit some nitpick and they're making a bloody fortune on their attorney's fees that then your client is basically having to pay. And so those are the damages that are coming back against you. So to me, it's very significant. It is a growing business. You get plaintiff's attorneys who can't find work, and they see this as a great opportunity. It's the next best thing since asbestos litigation, I guess. Okay, I think that kind of wraps up our time. We're at 2:03. And I hope that you have found this useful. I have provided, again, good information in the slides. I'm going to go back and fix some of the typos before we provide these to you. So, Laura, I'll send you a new set. Also, there's a wealth of information on the websites that I have cited, and I would commend you to download that and use that information to help you make some decisions on these issues. Thank you very much.
Thank you, Kent. You are an awesome resource, and we are honored to have you today. Learned a lot. I want to thank PUA as well for their partnership in arranging this today. As a reminder, you will receive an email tomorrow with a link to be able to get your certificate of completion. If you would like your AIA credits, please also respond to that and have your AIA number. Thank you for everyone attending today. We appreciate it, and I hope you learned something, and everyone have a great day.
Thank you. Bye.